Hello and welcome to the Patent Pending Made Simple podcast. I'm your host, Summer Shah, and with me are two very special guests, Logan and Bobby. Bobby, do you want to introduce yourself? And then Logan, do you want to introduce yourself?
Thank you. Yes, that's sweet of you, Summer. So I am a patent attorney. I used to work with Summer many, many years ago. We did ANDA litigation, and I helped him win, I think he won, a federal circuit case.
That's right. We did win.
There we go. Regardless, you win, right? Because you win on some issues, you lose on some issues. We'll call it all win.
That's right. We won on the most important issues.
There we go.
At least that's what I remember.
Same, same. And I got Logan with me. I'll let him introduce himself.
I am Logan, Robert's son.
You don't have to be so formal. You call me Dad's
Yeah.
son.
And Logan, how old are you for our audience, just so they have some context here? They know Bobby and I are old, so tell us. 10. All right. Today, I think we're going to be talking about an invention that you and your dad came up with. Is that right?
Yeah.
Awesome. All right. So you and your dad came up with an invention. Is that right?
Yeah.
Awesome.
So I'm gonna embarrass Logan and give you the Shark Tank pitch. So we noticed in soccer you had to buy shin guards, but in gyms there was no device to strengthen your natural shin guards. This is where
Mm.
we got the idea for our invention.
Shin-credible.
Can you hear that?
Ooh, I love that. Okay. Shin-credible. I like it because I can already visualize or imagine what this thing is going to help me do. So that makes the consumer's job a lot easier. So good job on the naming. We'll talk about this, but I like the name. I like where you guys are heading.
Thank you. So what does it do, Logan?
It strengthens your tibialis anterior muscle.
And what muscle is that?
That is the muscle that is irritated when you get shin splints.
That's right. And that you feel those in soccer often. Well, we filed a Georgia Shin Corporation. Actually, not really. We filed an LLC.
Nice.
But it's Shin-credible LLC, and we filed a provisional patent application in summer. No one better to talk to about that than you.
Yeah, I am glad. For our audience, I think the way we're going to structure this interview is we're going to pretend like you guys are a client who's called a patent attorney, and you guys are like, hey, help me. I know you got, Bobby, you're a patent attorney, but
I can use all the help I can get.
yeah, right. So we're just going to pretend that you guys have some questions about what to do, right? Because a lot of our listeners are inventors just like you guys, and they have questions about what to do. And Logan, not every inventor is so lucky as to have a dad who knows what they're doing and can help you protect things and invent things. So that's what this show is about, is helping inventors protect their ideas and guide them in terms of what to do next. So we're going to do a little bit of that. So don't hold back, ask all the questions you want, but I'm going to be asking you guys some questions too.
Okay, sounds good.
Awesome.
You go ahead and fire off a question to us, Summer.
Okay, so before I fire off my questions, I will say this. That's awesome because, Bobby, I was telling you this earlier, but I've never had shin issues in my life until recently. So I used to run, just to give some context, ran like mini marathons, several half marathons, played a lot of competitive tennis, never really had shin issues until I started running again a couple years ago. And I got these crazy shin splints, and I couldn't find a way to get rid of them. Like all the advice, everything I read was just like rest. So I just rest for like 3-4 months until I thought they would go away, start running again, get shin splints again. So it was very frustrating. And there's really nothing out there other than like some YouTube videos I found about this guy who had a stretch band, and you could help you like work out your shins. That helped. But there's very little out there. So I'm glad you guys are thinking about this. There needs to be a solution in the marketplace, and you guys thought of one. That's awesome.
Thank you. Yeah, same here. I was trying to come up with ideas for Logan. He wanted to do strength training for his legs, and you got the quads, and then you balance it out with the hamstrings, and then you do the calves. But there's no machine in the gym at least in the ones we go to, where you can balance it out the front part, which is the muscle that gets sore playing soccer. So
That's right. That's right. Yeah, very good. Okay, so you have invented this thing. And then the next question that people usually ask me is it patentable? So I'm sure you guys thought about this. And Bobby, can you walk me and maybe our listeners through what went through your head in terms of patenting this thing? And then we'll talk about some other things as well.
well, as you and I ran into, the 101 issue is quite the patent eligibility question happens a lot. And so I was excited when we came up with this idea for something that is like, okay, the examiner can't say this is an abstract idea. We have a tangible thing, not some app, which is what I usually come up with. But Logan here helped me come up with like an actual device. So what we were thinking about is, what do we want it to cover? And is it really novel? And so we were thinking about the basic function of the device. And we also were thinking about, what could it potentially do? Like, we thought you could put sensors on the whatever the resistance is and figure out the resistance, and also put sensor on the motion, on the part that moves, and you send that through a transmitter to an app, and it can figure out sets and reps. And I was thinking maybe you could have that connected to something like Max Preps, and have like some kind of soccer performance website, and you could see if there's any kind of correlation between using our Shin-credible product and improvement in soccer performance. So that's in the patent application, something we were thinking about. Anything else, Logan, you want to add?
No.
Okay. Well, you also said you wanted to make a version that was very durable. It was made out of titanium. And what were you going to call it?
The
I
Shin-destructible.
like that. I love that.
So that might be more of a trademark thing, but that's the titanium version didn't make it into the patent application.
Yeah, we should talk about that. So, first of all, you're right, Bobby. For our listeners, Bobby and I do a lot of software patent applications, and we run into issues with software patents called Section 101 or patent eligibility, which software patents in particular have a hard time with, because there's a rule of the patent office that says you can't protect an abstract idea. And a lot of software patents run into this issue. If they're not well written, they can be considered an abstract idea. That is not something inventors with physical products have to worry about, which is nice, because that Section 101 analysis is complicated, to say the least. So, I think there are a handful of requirements in order to get a patent. Patent eligibility is one of them, which you already met. Then the next two requirements are novelty and non-obviousness. Novelty just means that nobody's done it before, and non-obvious means that it can't be an obvious modification of something that already exists. So how did you answer that, Bobby? Did you guys go through and search products that were similar, perhaps, to see if something like this existed or anything like that?
Yeah, I did a search, not when we were doing the invention, but just when I wanted to see what was out there to actually, we're like, we're going to buy this thing if it exists. And the only thing we saw was like a free weight style machine. It does a similar motion, but you put plates on it. I didn't see anything that was like a self-contained resistance like what we have in mind. So yeah, I only saw one product, and like you said, there's bands as well. I guess you could put a band on your foot and do a similar motion. But
Mhm.
so just before we got the idea to launch the invention, just in looking like on Amazon to buy something, we realized that it didn't exist. So I think the novelty is there just from our looking shopping for it, and then realizing it doesn't exist, and then
Mhm.
the idea to invent it. Non-obviousness, it's always a fight. I mean,
Yeah.
I expect it to be a fight, but I feel like the novelty bar, if you know it's novel, then it's good enough to file, unless it's super obvious.
Yeah, that's right. That's a great way to put it, because Bobby, you and I've developed maybe a finer sense of what's novel and non-obvious. But I can imagine an inventor who's listening may not have that same context or understanding. So being able to do what you just did, which is to figure out, hey, does this thing exist? And if the answer is no, then you're in pretty good shape for generally filing. And so, yeah, love the way you put it. Obviousness just means that, would it be obvious for somebody to put a couple of things together to come up with your invention? That's a hard question, even for patent attorneys to answer. But I think as long as there isn't a product out there or something out there that's like your invention, I think generally you're in the ballpark of
Yeah,
patent.
and I frequently disagree with the examiners about what's obvious, and we gotta go back and forth and bring in the P tab as an arbitrator.
Yeah, it's according to patent examiners on first review, everything is obvious, but we almost always win those arguments, right? If it's rejected on obviousness grounds, we'll overcome that rejection usually.
Yeah, hopefully.
Okay, awesome. So the first thing you guys did was see if this product is out there. That's very good. I think that's a great first step. Then you filed a patent application. I think that's a great second step.
Well, hold on, sorry.
Okay,
The next thing we did was filed an LLC.
good. Okay, very good.
We waited for the Georgia Secretary of State to tell us we had our LLC, and then we filed the patent application.
Okay, very good. LLC to me makes a lot of sense in this case, but for our listeners, there's different types of corporate entities that you can form. The primary reason to form a company is to limit liability, right? So this is what we learned first year of law school, Bobby, that some kind of a legal entity can protect you and your personal assets from liability. You make this thing and sell this thing, and God forbid it hurts somebody, that person wouldn't be able to come after your personal assets, right? They can come after the company's assets.
Yeah, and let me ask you, how would you typically advise a client? Would you advise them just to get the patent application in their own name, or would you advise them to form a company, or if they have an existing company, to file it in the company's name, or is it just
Yeah,
sorry,
that's a tough one. No, no,
does
that's a
the
great
the
question.
small entity or micro entity status play into that?
Yeah. So the legal answer is you should form a company, at least an LLC, whenever possible and as soon as possible. Okay. But sometimes my clients don't know what they're going to do with this, right? Sometimes they have a long developmental pipeline or cycle. So they invented something today, but they're not actually going to sell it for, let's say, another year, right? Because
Right.
do some prototyping, partnerships, all sorts of legwork that you have to do. In that case, I can sometimes see that it's okay to skip it, just put it in your personal name, and then we can transfer ownership into the company in the future whenever you're getting closer to like something associated with a liability. Okay. So that's something that we do sometimes. Sometimes the clients don't know if they're going to raise outside capital or not, right? If they're going to go to investors and raise money for their product or venture. In that case, they sometimes wait as well, and I'm okay with that because venture capitalists, they're not going to invest in an LLC. They're going to want to invest in a Delaware C-Corp usually, right? So in that case, if they're still trying to figure out, hey, am I going to bring on investors or not? What is the nature of those investors? Sometimes it's okay to wait. Sometimes my clients already have investors on board, right? They've already taken on money and then they ask, hey, can I just put the patent under my name personally? And I'm like, no. If somebody's going to invest in this thing, they're going to want to have, invest in a company that owns the IP rights, right? Otherwise, that deal's going to fall through or it's not good faith, right? If you've already taken the money. So those are some of the things, some practical considerations for clients.
Ye-
But yeah, legal answer is file something. If you're going to raise capital, file a C Corp in Delaware. If not, form an LLC in your state.
Interesting. So I'm not a corporate lawyer.
Neither am I, by the way.
One of the trends I've noticed is formation in Nevada.
Oh, yeah. Yeah. That's also kind of a tax advantageous situation. So, because you're not building any revenue anytime soon,
Yes.
you're okay. Like, none of these things really come into play. But, like, if you were going to start generating a bunch of income tomorrow, then all of this becomes much more complicated, right? Or you need to talk to a corporate attorney and a tax attorney at that point because you can have different tax liabilities depending on the state that you incorporate in. A lot of Silicon Valley investors, they won't invest in anything other than a Delaware C Corp, right? They'll just like make you redo your formation paperwork. And that can sometimes cost tens of thousands of dollars to rework it. I had another guest on this podcast. We haven't released this episode yet, but she started off as an LLC. For 5 years, she ran it as a single owner business, and then her business took off and she started getting interest from venture capitalists, and they were like, yeah, we'll invest, but you need to be a Delaware C Corp. And she found an attorney who was like, yeah, I'll convert your LLC. She's from Virginia, her Virginia LLC into a Delaware C Corp. The bill was $12,000.
Maybe I should be a corporate attorney.
Yeah, right. I was like, well, that doesn't sound right, first of all, but yeah, that's very expensive.
Yeah, I was told to ask this, but I don't know what this means though. When should we convert to non-provisional?
That's a great question. So you filed the provisional. So your dad knows this, but you have 12 months from your provisional filing date to file the non-provisional application. So what I would recommend is wait the full 12 months, right? Wait as long as you can because you already paid the fees for provisional. So you might as well make those fees work for you for as long as possible because when you do the conversion to a non-provisional, you have to pay an additional fee. So you want to try to delay that for as long as possible. But on the flip side, let's say this thing takes off, right? Like, let's say we post this podcast and people are like knocking on your door and they're like, hey, we want this thing. Then you may want to consider converting sooner, right? Depending on what the market is doing with this invention and this product.
In that vein, I know you do a lot of fast track, right? What do they call it? Tier 1?
Yeah. track ones.
Track one? Yeah. Can you tell me about that process?
Absolutely. So we, for our startup clients especially, will often file a fast track application. So normally, when you file a non-provisional Logan, it takes the patent office almost 2 years, sometimes longer, to review your patent application. Okay, it just sits there in a pile until somebody's ready to look at it. And the backlog at the patent office for most examiners is about 2 years. So nobody's going to look at it for that long. That's too long for some clients, right? For especially for startups who are moving at lightning speed. So we'll file a fast track request where you basically pay an extra fee. It's between 1,000 or 2,000 bucks, and they put your application in the front of the line. So usually the examiner at the patent office will review your application within 3 or 4 months as opposed to 2 years.
Okay, that was great information. Summer, I got to ask you another question about trademarks.
Yeah,
Do you deal with them? Like, do you file any trademark applications?
I have not. I don't know a whole lot about trademarks other than what I learned in my one trademark class in law school.
Hey,
I will do my best to see if I can answer your question though. No, no, I think it's good. If I don't know it, I don't know it.
do you have a sense of what classes, like, I mean, the question I was going to ask, which I think might be unfair, but what classes would you, or how many classes would you advise someone filing a trademark to go after?
Good question. I actually don't know.
Okay.
But for our audience sake, I would say this, that trademarks, unlike patents, are categorical. So when you file a patent application, that patent is protected no matter what somebody does with it, right? So if somebody makes the same product as what you have, and if they use it for some other thing, they still infringe your patent. Trademarks are not like that. So trademarks exist in categories. So you had to specify which category you want protection in, and then you'll get protection in that category. So to give you some example, like Starbucks, right? Like their trademark would be in the coffee or retail chain operations categories. So if you wanted to have a Starbucks oil change company, right? Like probably could. I mean, there's some exceptions to this, but they exist in categories and you're only protected in the categories that you specify in your trademark application. And that's why you can have like Delta faucets, for example, and Delta Airlines, right? Because they can exist in different categories of business.
Yeah, exactly. I was looking myself and, uneducated, but my look was I was thinking there were 3 candidates. There was one for like health, like I was thinking like what you were mentioning, the rehab aspect of it. So like that could like it seemed like there was like a healthcare product category. Then there was something called sports and toys, and like that would be like what you would see in the commercial gym, I think. And then there was a category just for apps. So I was thinking like all 3 of those were possible candidates.
Yeah, I don't know. I'd have to ask a trademark attorney or Bobby. The other thing that comes to mind is to find a product that's kind of similar to yours. Not
Yeah.
similar in the sense that it does the same thing, but like it has the same kind of general audience or product categories.
Right.
Look up their trademark, see what categories they're in, and then just copy that.
That's great advice.
Yeah,
So
and for our listeners, that's something you guys can do too. There's a trademark database called TESS, TESS. You can just Google that and find other companies, right, with similar types of product lines and see what categories they've claimed, and that gives you some guidance in terms of what you should claim as well.
Summer, we've come to the end of our questions, but we're gonna turn your show back over to you and let you ask us questions.
I love it. This is great. What I was hoping to cover was some corporate stuff, some patent stuff, some trademark stuff. Maybe we should talk about copyrights a little bit. Have you guys thought about that? Have you done any copyright work around this, Bobby and Logan?
No, we haven't.
Okay. I'll give you guys especially for our listeners' sake, a really quick overview on copyrights. So copyrights protect creative works of art. So trademarks will protect the company's name and the logo and things like that. Copyrights will protect creative things that you make to help sell the product. So, Coca-Cola, for example, the name Coca-Cola is a trademark, but the Coca-Cola polar bears, for example, are copyrights, right? So if you take photographs, if you make artwork to support the product, those would be all things that you can copyright.
Yeah, so I do have a question now. I sketched out like a version of our Shin-credible product. Then I gave my description to ChatGPT, and then it made a drawing that was pretty much the same thing I drew. Could I then print that out, send it to the copyright office, and be like, "Here's my copyright"?
So that would require a copyright attorney to weigh in.
Okay.
Yeah, I also took one copyright class in law school. It did not help answer this question, but actually, I think this is a kind of a area of law that is under a lot of heat and scrutiny right now.
Right.
So I don't even know if there is a very good answer one way or another yet.
Well, I'll say this, the version that ChatGPT gave me was like the same thing I sketched. Then I gave it to Gronk and like, I'll put it this way, ChatGPT gave me the Flintstones version, Gronk gave me the Jetsons version. It was unrecognizable. It looked like I don't know, like a Dyson vacuum cleaner.
My goodness. Just a little bit different, a lot of creative liberty there.
I wouldn't feel right sending that one to the copyright office, but
That's right. That's right. Yeah, we should have a copyright attorney on this podcast at some point because this, I bet a lot of people are doing this who are listening to the show, right? They're just going to ChatGPT to help them with illustrations or help better visualize their invention and their product. That's an open question. Yeah. Okay, very good. Now, the last thing I wanted to ask you guys about is commercialization. How do you plan to make money from this invention now that you come up with it and you've done a lot of the legwork that you need to do to legally protect yourself and set yourself up for success? But what are your goals? What are your plans in terms of making money from this thing?
honestly, what were you thinking, Logan? I was thinking we'd go on podcast and talk about it and hopefully get some interest that way. What were you thinking, bud?
We would sell it.
How about we're gonna make a version, Logan's gonna use it, and then he's gonna dominate his soccer league, and then they're gonna be like, what was the secret?" He's gonna be like, "I got a Shin-credible secret for you."
Yeah. He's going to be like a soccer influencer and he's going to be
Exactly.
like, hey, this thing helped me a lot.
Yeah, exactly. That's the plan. To be honest, I don't really know. I mean, it's kind of a interesting product and I mean, interesting project for me and him to do together, but
Yeah.
I don't know. I'm interested in any ideas you have for commercialization.
Yeah, the reason I ask is because a lot of a lot of listeners, especially, right, are not thinking about this yet. Because inventors by nature are like engineers and tinkerers and thinkers, right? And oftentimes they don't think about the commercialized aspect of it, right, or the commercial impact. So I always like to start my conversations with them with that in mind, right? Because outside of that, the patent can just be a very expensive piece of paper. For you, Bobby, I know it's a little bit different here, but for our listeners, you really should be thinking about how you're going to commercialize your invention and make money from it. Because that helps you answer a lot of the questions that we just went through, right? Is it worth spending the money on a patent? Is it worth putting an LLC together? Should it be an LLC or should it be an S Corp or a C Corp? All these questions that you need to ask can be answered by just having an end goal in mind. The other thing I always say is that the type of end goal you have in mind may dictate how we write the patent application, right? Or if we need to prioritize between a trademark and a patent, that can help us too. But broadly speaking, for inventors in particular, there's two pathways to commercialization, to making money. One is to make the thing yourself, right? And you can package it, market it, sell it, ship it. Those things, those would become your responsibility, right? And you can certainly find vendors to help you support that, but it's a job, right? It's a lot of work if you need to do it. But you can potentially make a lot of money that way too. The other option is called patent licensing, where you can license or lease the rights to your invention to another company, and they will make it, they'll sell it, they'll do all the work, and they'll write you a check for renting or using your intellectual property or your patent. And often my clients who go that route will get a check in their mailbox like once a quarter or once every 2 years, once a year, twice a year, something like that. So those are some things to think about because that can influence what you spend your time on next. Now that you have invented this, do you need to spend time finding licensing partners or should you spend your time prototyping this and finding manufacturing partners, that kind of thing?
Do you have any suggestions for me or the audience on how you would go about finding a manufacturing partner?
That's tough. It will connect you to a couple of people who might be a good starting point, but that's a little bit outside of my area of expertise as well. It's changing a lot, right? So like early prototypes, a lot of my clients are doing like 3D prototyping and things like that. And then for the actual manufacturing, it really depends on the nature of the product. Different manufacturers have different expertise, right? They have different things that they work on at different scales. So you just got to talk to a lot of people and find the right person who has expertise in making your thing. Because, like, you can have manufacturers who make pillows, for example, right? And that's not going to help you very much. They make heavy equipment, and that's not going to help you very much. So you just got to find that kind of sweet spot.
Yeah.
There are also manufacturers who specialize in making, 10 million plus of something, right? That's not going to be what you need right now.
Right.
It's a lot of just, meeting, networking, getting more connections, and finding the right person.
Do you think with the tariffs, it'd be a lot less likely that we're gonna shimport this invention?
I don't know about that. I know that all my clients who are doing overseas manufacturing are scrambling.
Yeah.
Everybody, I had a client who moved their operations or were in the middle of moving their operations and then moved it again because the landscape changed again on them, right? As they were
Seems
making
like
the
it
move.
happens daily.
Yeah. Yeah. It's a unpredictable environment to say the least.
Yeah, yeah, it seems like where I go to check my crypto prices, every time it's like updates the tariffs or whatever, and it seems like it's happening. I don't know how often it's actually happening, but it seems like it's all the time. I can't imagine having that.
Oh my gosh, yeah. Yeah, no, they're all stressed out. Several clients have like moved overseas for a couple of months just to help like shepherd all the stuff around.
Yeah.
It's a tough spot to be in.
Well, thank you for your time, Summer. I'm gonna assume what we said was attorney-client privileged, and, we can now see you for malpractice. No, I'm just kidding.
That's right. That is, people ask me, they message me and they're like, hey, why don't you have more inventors and practical conversations? And I'm like, well, you got to understand there's this thing called attorney client privilege. When people talk to me, they have often an expectation of privilege, right? Because they're talking to an attorney. And sometimes they say, I'll waive it. I don't care. I'm like, I don't know if you realize what you're doing, if you understand the implications of it. Bobby, I think you agreed to waive privilege, and I trust that you know what you're doing, so I'm not worried about it. But this is helpful so we can have a more candid conversation here.
Exactly. Yeah, agreed.
Yeah, awesome. All right, very good. Well, this is an awesome product. You guys have made an incredible amount of progress for how little time you guys have been working on this for. So, congratulations. Congratulations, Logan. And I'm looking forward to seeing you on YouTube working out your shins and kicking ass in soccer.
Thank you.
Stay tuned.
Yeah,
It's gonna be happening.
yeah. I look forward to it.
Alright, well, thank you, Summer.
Yeah, thanks, guys.
The Patent Strategy Podcast is recorded for informational purposes only and should not be considered legal, business, or professional advice. We are not responsible for any loss, damages, or liability that may arise from the use of this podcast. The podcast is not intended to replace professional legal advice and should not be treated as such. The views expressed in this podcast may not be those of the host or the management.